ladies and gentlemen, and welcome to the latest in a never-ending series of Berkeley Memorial Lectures. Clifford Berkeley was an entrepreneur and financier who was a governor of the school for many years, and his son, Stephen Berkeley, is now on the LSE Council, and the family have supported this lecture series for a long time, mainly having distinguished professors in the school and giving them an opportunity to talk perhaps more broadly about their subject than they would normally do. And this evening, we're delighted to have someone whom I am only just getting used to thinking of as Judge Sir Christopher Greenwood. Until recently, he was here just as an ordinary communal garden law professor, whom I could, as a head of department of the law department recently, I could sort of order him around. But now, of course, I must bow and scrape and tug my forelock appropriately. But here we are tonight, really, in a sense, to get to the bottom of a mystery. How is it that a man in the prime of his life, with a glittering academic career ahead of him in what is now officially, according to the government's assessment, the best law department in the country, how could such a man decide to throw all that up and go and sit on some obscure court in a flat country in the soon-to-break-up Eurozone? Well, perhaps we may learn some insights into this mysterious decision as Chris tonight talks to us about how, or can, international law change the world. I think he is in a slightly betwixt and between state in that he has stopped sort of being a law professor but hasn't quite become a judge. So you catch him at an interesting moment when he is entitled to reflect certainly on the broader issues, though of course not on individual cases which might be coming up before the court. But I don't know quite what he's going to say, so I shall stop there and hand over to Chris. Thank you.
Well, thank you very much, Howard, ladies and gentlemen. The answer to your question, why did I give it all up, is simple, Howard. If you'd mentioned the glittering academic career I had in front of me a few weeks ago, I might not have done. It's so sad that you only got round to mentioning that at this late stage. I am also now not strictly any longer in a betwixt and between state. I have taken up my position as a judge at the International Court. Therefore, I am not in that unhappy position of not being paid either by the university or by the United Nations. The director said that this was the latest in a long line of Clifford Berkeley lectures given by professors at the school. Some of you, particularly those from the law department who were here last week, may feel that it is simply the latest in a long line of Christopher Greenwood's farewell lectures. I shall, however, I promise you, endeavour to say something different from what I said last week in the dinner for the alumni. Clifford Berkeley was not only a generous benefactor to the LSE, he was a real friend of the school and an enthusiast for everything the school did. It's therefore a particular honour to be invited to give this lecture in his memory, and I'm very grateful to his family and to the school for inviting me to do so. Both in his business interests and in his interests in the university, Clifford Berkeley would have been well aware of the fact that the community in which we live and work today is more international than it has ever been in the past. It's appropriate, therefore, that tonight's lecture should say something about the role of law within that international community. Now, let me say straight away what I'm going to be talking about when I refer to international law. It's not the law of other states. This is one of the great misconceptions particularly favoured by those who choose to study international law in the hope of getting free trips to as many interesting places as possible. Having made that mistake many years ago, I can tell you from experience that international law is in fact the law that applies between states rather than within any one country. It's to be found today in a growing number of treaties or agreements between states, and sometimes between states and international organizations like the UN, and in a body of unwritten principles which we refer to as customary international law. What does it deal with? Well, it deals first and foremost with those areas of activity where the interests of one state bump up against the interests of another, whether in the form of physical boundaries, such as the boundary between the land territory of two states, or trying to find a dividing line between their maritime spaces, or boundaries of a jurisdictional character. For example, to what extent is the United States entitled to treat as criminal the activities of a banker here in the United Kingdom? And it's in these areas where the interests of one state can easily clash with the interests of another, where one sovereignty is juxtaposed against another, that international law has its most important part to play. But it also deals, as we'll see, with areas of international cooperation, areas where it's not a matter of one state's interests conflicting with another, but rather that the only solution to a particular problem has to be found in some kind of societal action, some kind of group activity. A technical but nonetheless very important example would be international air transport. The director, who seems to spend a large amount of his time flying between Britain and far-flung places, tells me that he arrived back here only this morning from Singapore, having managed to get himself one of those first-class suites on Singapore Airlines that I've never managed to travel on, and previous to that had flown from Hong Kong to Singapore. Now, that flight is made possible by a number of things. It's made possible by the fact that Blériot realized that although what goes up will eventually come down, you can adjust the time when it comes down, and rather more importantly, the manner of its coming down. But it's also possible because of the network of international agreements which tie states in to a consensual system for air transport and allows an aircraft registered in one country to fly over the territory of another and to land at the airport of a third. Now, there has been a vast expansion of international law in recent decades. In some respects, that simply reflects the expansion that has taken place in law generally. You find it in this country as well. 150 years ago, the Prime Minister, after winning a general election, was asked what his programme was going to be, and he replied with patrician disdain, "What sort of programme did you have in mind? We might have a little law reform, but we can't go on adding to the statute book forever, you know." Now, sadly, his successors didn't see it like that, and we now have this vast body of British domestic legislation, and to a large extent that has been mirrored by a growth in international treaty law in particular. But it's not just that there is more law. There are more areas of activity regulated by law than there used to be. So the last few years have seen, for example, the emergence of bodies like the World Trade Organization and a very substantial body of legal regulation of the extent to which one state can impose tariff, quota, or other barriers on another, opening up matters such as public procurement policy in different states, though with differing degrees of success. Human rights has been an area in which international law has been transformed in the years since the Second World War. Environmental law, a subject that nobody talked about at all when I was a student in the 1970s, now one of the major concerns of international lawyers today. So if that is what international law is, can it change the world? Now, I have to let you in on a secret here. As somebody who spent his entire adult life teaching international law, practicing international law, and now taking on a job as a judge of international law, I'm not going to say no as the answer to that question. I follow the well-trodden path of the academic, or the erstwhile academic, never break your own rice bowl in public. But I do have to admit that I slightly regret having picked this title. I picked it more than a year ago. Today, with the worldwide banking crisis, global recession, the threat of climate change, global warming, terrorism, a better title might have been, "Can International Law Save the World?" But the question that I did pose, and I'm going to have to stick with it, the question I did pose gets very different answers from different groups of people. And it's perhaps worth looking at 4 of the main schools of thought on this subject. I'll call the first one the Dreamers, or the Romantics. The Dreamers were in their heyday just over 100 years ago at the Hague Peace Conferences in 1899 and 1907. Large numbers of men and a smaller number of women went to those conferences firmly believing that if they got the law right, they could replace war with peaceful international adjudication. Not just some of the time, but for all situations, forever. They could, in Tennyson's words, produce a world in which the kindly earth shall slumber, lapped in universal law, the closing line of one of the famous stanzas of his poem, Locksley Hall. And those dreamers weren't to be found only in the ranks of what we'd now call the NGOs that attended the conferences. Many of the governmental delegates believed this as well. And indeed, not just in the early part of the 20th century. Many went on believing it. President Truman, who was responsible for the creation of the United Nations only 40 years later, kept a copy of that part of Locksley Hall in his wallet for most of his adult life. Now, the dream was certainly a noble one, but no one would suggest we have come anywhere near realizing it. And that leads on to the second group. If my first group, the dreamers, would answer the question, can international law change the world, by saying enthusiastically, yes, of course it can, and this is how. The second group are the disappointed, the dreamers who've seen that they didn't get what they dreamt about, those who wanted Locksley Hall's world of peaceful slumber and are frustrated that it hasn't materialized. Now, their answer is they would like to change international law to change the world. They think it should change the world, but they're fed up that it hasn't done, and they've lost faith in whether it can. And then we have the third group, the cynics, the realist school, as they prefer to be known, epitomized by Hans Morgenthau in the years just after the Second World War. The cynical school maintain this is all complete nonsense. States will always act in their own national self-interest. Always has been like that, always will be like that. And for most of them, though not quite all, that's how it should be. So the idea of a system of law which somehow limits the ability of states to act in their own self-interest and makes them place some other goal above selfishness is simply utopian. It's unrealizable. Either the international legal system becomes just an extension of politics by other means on this analysis, or it is totally and utterly ineffectual. And then we have the fourth group, which is a rather crude offshoot from the cynics or realists. I'm not quite sure what to call them, so I've termed them the bloglodites, because you'll find their views most regularly expressed on the web blogs, particularly some of those emanating from North America. These are people who not only think that Tennyson's goal is unachievable, they're absolutely determined that it's not going to be achieved. And they started worrying a bit about whether it might be. So they post blogs in which they say that the United Nations has a covert plan to take away every American's firearm. Now, this will be news to the Secretary General of the United Nations. I don't think disarming the whole of the United States is in his in tray at the moment. I don't see how it could be in his in tray in terms either of the power that the UN has or the legal authority to act that it possesses. And in fact, that blog is a crude caricature of this view. But underneath it, there lies something rather more serious, a school of thought that is actually genuinely concerned about international law taking away some vital state rights and interests. Now, there is a pantomime quality, ladies and gentlemen, to this debate. You have one group saying, oh yes, it can change the world, and another group saying, oh no, it can't. But what all of these groups have in common is that they take an extreme version of what you might hope to achieve through international law. And then they judge international law by whether or not it has in fact achieved that extreme view. Now, I don't think that that is a particularly useful way of analysing the situation. It's better surely to take a step back and ask ourselves, what can any system of law realistically hope to achieve? What is law for? What can it do? How do you measure its successes or its failures? Now, if you do that and you look at systems of national law as well as international law, a number of things become rather clear. First of all, the cynics may have thought they'd discovered something blindingly original when they started saying that states will always behave in the manner that they think best suits their self-interest. But that's exactly what everybody else does as well. It's what most people do. It's what corporations do. It's what national governments do. It's what local government does. It's what trade unions do. Now, they may be better or worse at identifying what their self-interest is. Their self-interest may be viewed in an enlightened or an unenlightened way. But they are nevertheless essentially seeking to achieve their own self-interest, their own personal goals. Another thing which becomes clear if one looks at legal systems as a whole is that the idea that a legal system is or is not political is a grotesque oversimplification. It's often said that international law is highly politicized. But of course, one essential part of the legal process is always highly political, and that is the making of law. Law emerges not through some mystical process, but because a political process through a legislature creates new law. And there's nothing the matter with that. It's as it should be. Where politicization of law is fundamentally wrong is if it infiltrates into the process of adjudicating rights. If courts, if arbitration tribunals, those who have to apply the law, sacrifice the application of a good faith understanding of the law for some political self-interest or political gain. And that's where the real danger lies. And the third point which becomes clear is that no legal system can be better than the society which it serves. The stronger and more cohesive the society, then almost always the better the legal system which it will produce. Now, in part, that's a matter of legal institutions. It's a matter of having a strong legislature, a strong court system. It's no accident, for example, that when Henry II embarked upon a programme which transformed the nature of British governance, or English governance, I should say, he began by ensuring that his own judges, the king's courts, dominated the legal system and could prevail over any feudal baron's legal authority. So strong legal institutions are a critical part of this process, but they're not the whole story. At the time that it imposed prohibition after the First World War, the United States had extraordinarily strong legal institutions. It had a very strong and vibrant democratic tradition, a strong Congress, a fairly strong presidency, and a very powerful court system indeed. Yet prohibition was a complete disaster. It lasted barely 12 years, and despite all the support which had existed for it at the outset, despite the attempts to enforce it by those who passionately believed in it, it simply proved unworkable. In practice, law will only help to bring about change within a society if it is in some way in tune with the general views, the general current of that society. You perhaps see a good example of how that can work a generation later in the United States, with the way in which segregation in the southern USA was broken down. The process of breaking the segregation in states like Mississippi and Alabama was the result of a mixture of some incredibly courageous decisions on the part of judges in mainly the federal courts in those states. Judges who often lived very isolated and very threatened lives. Some of you may have read the obituary a little while ago of Frank Johnson, who was one of the district judges in Alabama. Johnson was responsible for some of the most important desegregation judicial decisions. He was a keen golfer, but no golf club was prepared to admit him as a member because of his views on the race question. So every Saturday he played golf on his own at Montgomery Air Force Base. They had to let him play there because he was a federal judge and this was a federally owned facility. But nobody was prepared to actually go round the golf course with him for most of his life. But those judicial decisions, the legislation which Congress eventually passed on equal rights, have to be seen in the context of a change in political will at the federal level to enforce those laws, and gradually a change in attitudes and opinions in most of the key states concerned. The process was a symbiotic one. Without the law, it couldn't have happened, but the law alone was not going to produce it. And one final observation, if I may, in that area, and that is that fundamental change in societies, as opposed to incremental change, is really quite rare. It tends to come about only when there has been a dramatic political upheaval, such as a civil war. And as we'll see, the same is true in the international arena. Now, certain features of international society are very important in this respect. The first one we perhaps need to think about is there such a thing as international society or an international community at all? Professor Posner of the University of Chicago was an emphatic believer that there wasn't. There could be no international law and no world court because there simply wasn't any international society. Now, I think if you dig a bit deeper, that's a little bit like Margaret Thatcher's famous comment of 20 or so years ago that there's no such thing as society. She meant rather more and perhaps rather less than she was quoted as saying. The same, I think, is true of Posner. Of course, international society is not like US society or British society or Japanese society. But to suggest that there is no such thing as international society at all is very strange, because you do have 192 countries. They do interact one with the other. People do move between them. Their legal systems do bump up against one another. And there are international courts and institutions to enforce the international laws those governments agree upon. So a society of some kind, yes. But it is a rather strange-looking society, if, that is, you expect it to look like the society of the United Kingdom or the USA. If you look, first of all, at its legislative capacity, there is no parliament in international society. There's no legislature which can pass a statute binding on everyone, whether they voted for it or against it. Instead, there is the process of law being agreed upon voluntarily in the form of treaties. But of course, a state can choose to become a party to one of those treaties or not. There is no legal requirement to comply with the Rio treaties on climate change, for example, unless the state chooses to sign up to them. The only law that binds everyone, irrespective of their choice, are the principles of customary international law. Another problem with the legislative process in international society is that there's an element of chaos about it, in the sense that each treaty tends to be negotiated in isolation from what is going on in other parts of the legal process. I think there has been a very substantial effort to avoid that, particularly on the part of some governments. But 10 years ago, for example, when I was researching for the Pinochet case, which we were about to argue, I had to look into the way in which the Convention Against Torture had been drafted. And it's plain that that treaty was negotiated through the middle 1980s without any regard whatsoever to the question of sovereign immunity. And likewise, discussions of sovereign immunity at the time were carried on without anyone looking at the question of how this would apply in the case of somebody who was charged with a crime under international law. All too often, you find cases where two different bits of international treaty law have been negotiated in complete isolation, one from the other. Now, that does happen in domestic law as well. Anyone who's tried to reconcile listed building regulations with disabled access, fire safety legislation, or health and safety of employees will know that a certain amount of chaos is inherent in any legislative process. But it's more advanced in international law than it is elsewhere. Secondly, there's a big difference in adjudication, because there is no system of compulsory courts in international law. The International Court of Justice, of which I'm a member, is entitled to hear cases between states only if those states have at some stage agreed to its jurisdiction. They might later regret that agreement, they might deny that it ever took place, but at some point there has to be an agreement that this dispute is one which falls within, or this category of disputes is one which falls within the jurisdiction of the court. And then there's a difficulty about enforcement of international law. There simply isn't the general machinery for enforcement that you find within the vast majority of states. And lastly, there is an issue in international law which doesn't really arise in the domestic legal setting at all, of competing legitimacies. Those who argue that a rule of international law should be disregarded often do so out of a passionate belief that there is a better legal system which they apply within their own country and which should be given priority. Now that's of course a view that I disagree with, but you don't really find any replica of that in debates about compliance with English law, French law and the like. Now these peculiarities are often seen as characteristics of international law, but it would be perhaps more accurate to say that they're features not of international law, but of the international legal system. Of international society as a whole. International society has shown no enthusiasm for a system of majority rule or compulsory adjudication. And unless it does, you simply will not have those features. They're not something which can be created by courts or can be created by a piece of inspired writing by a professor. So, if one looks at the question of can international law change the world, we're rather in the position of the man driving his big car, his Bentley, let's say, through some back roads in Ireland. He's totally lost. He stops and asks a man who's passing by, "How would you get to Kilkenny?" "Ah," says the passerby, "I wouldn't start from here." And that's exactly the position one is in international law. We wouldn't start from here if we could avoid it. But starting from somewhere else would require vast political change. Now, that has been attempted on 3 occasions in the last 2 centuries. At the end of the Napoleonic Wars, the end of the First World War, and the end of the Second World War, there were serious attempts to rebuild international society's fundamentals from the ground up. It has to be said that they produced very mixed and really rather disappointing results. And there's very little sign of a willingness to effect such a radical change today, except perhaps in the context of limited regional experiments, such as that of the European Union. So it's more useful, I'd suggest to you, to consider what can be achieved with what we have at the moment. And the answer is a considerable amount can be achieved, and indeed is being achieved at the moment. We have far stronger legal institutions in international society today than we did before the Second World War, or even in the early 70s when I was studying law at university. The International Court of Justice, the year that I took my master's degree in international law, decided no cases at all. It had only 1 case on its books, and the following year it decided it didn't have jurisdiction over that case. Now, its list is full. It's got cases from every part of the world, from a range of states that are certainly not the ones that would have had anything to do with the International Court 3 decades ago. The World Trade Organization is a vastly stronger legal institution than its predecessor, the General Agreement on Tariffs and Trade. The Security Council, largely moribund for much of the 60s and 70s, the Vietnam War, for example, never made it to the agenda of the Security Council at all, is today an extremely active body, perhaps the closest in many ways we have to anything like an international legislature. And the creation of the International Criminal Court and the specialized criminal tribunals for Yugoslavia and Rwanda have begun to chip away at the whole idea of individual impunity for violations of international law. But it's difficult to assess how effective international law can be if we just look at it in the abstract. I think it's more useful to consider it against a list of specific objectives. So what are the objectives which any legal system will seek to achieve. I think there are three that are critical to what a legal system seeks to do. The first, perhaps rather prosaic, is to hold the ring between competing parties. In the words of the old proverb, your right to swing your fist ends where my nose begins. There therefore has to be some way of establishing where one person's nose begins and where someone else's freedom to swing their fist ends. To some philosophers, such as Michael Oakeshott, this was perhaps the most important function that law had. Holding, not trying to achieve some common goal, but leaving each person with the maximum freedom to pursue their own individual goals, without doing so grotesquely at the expense of others. But the second principal goal is to facilitate the achievement of certain common interests, which simply cannot be achieved by individual action. And a good example in the international arena, as we'll see in a moment, is environmental protection. And the third goal, much more prominent today than it would have been a couple of hundred years ago, is that law should seek to protect the fundamental rights of the weak against the strong, and also to protect the fundamental rights of those who are perhaps not characterized as weak, but just ignored or marginalized within society. Now, what I want to do in the last few minutes of this lecture is to ask, to what extent can international law meet each of those objectives? If we look first of all at the objective of holding the ring between the competing interests of different parties, this was originally what international law was all about. International law was set up as a system of rules between states only. It didn't deal with the individual except in a very peripheral way, and its job was to ensure that competing sovereignties did not clash too violently one with the other. Now here, international law has, I think, a good story to tell in the last 50 or 60 years. If you look, for example, at boundary disputes, which almost invariably resulted in bitter political conflict in the past, and very often in war, there is an extraordinarily good record of achieving peaceful solution by court or by other third-party means in the last few decades. Now, that's not always a matter entirely of law. It may require a very considerable effort of political will as well. For example, if you drive today between Germany and France in the area of Alsace and Lorraine, one of the most heavily fought over parts of Europe, the only time you realise that you've crossed the border between Germany and France is when the road sign in the next town you come to is in a different language from the one that you've just left. It's extraordinary how political change there has knocked down the dispute about that border. But other parts of the world haven't been as fortunate. And the International Court of Justice, in, for example, its decisions in the 80s between Libya and Chad, and in the 90s between Cameroon and Nigeria, defused very effectively two extremely acrimonious and violent border disputes between those countries. Perhaps even more striking in many ways, though less well known, is the achievement of international law in respect of maritime boundary disputes. Starting in the early 70s, we moved with dramatic speed from a world in which each state's rights over the waters by its coast extended only 3 miles out to sea, chosen, I believe, because that was the range that a cannon could fire in the 17th century. The Norwegians had better cannon than everybody else because they had a 4-mile territorial sea by historical compromise. But we moved in only a decade from that system to one in which rights extended to 200 miles from the coast or even further, turning the Mediterranean, for example, into an entirely closed sea. There's not a single part of those waters that isn't now claimed by one state or another. And that could have led to a modern-day maritime equivalent of the scramble for Africa of the late 19th century, with very considerable bitterness between competing states chasing the resources that they considered to be their own. That hasn't happened is very largely because there was available a body of rules for dealing with it, institutions that could apply those rules, and the political will to refer disputes to those mechanisms rather than dealing with them on a unilateral basis. The World Trade Organization has, I think, in a particularly difficult time, done far better than one could expect in terms of preventing a backsliding into quotas, tariffs, discriminatory barriers as a means of protectionism. Whether it will continue to have that effect in the recession that is now with us, we'll have to wait and see. But it has a far better chance of doing so than any of the more limited mechanisms which existed under the GATT. Then let's turn to the question of whether international law can change the world through better achieving societal interests, cooperative interests. I mentioned air transport a little bit earlier. That has been something of a success story in which international law has played a useful, if perhaps a subsidiary role. But the obvious problem case today is environmental protection. Now, the reason why this is so central to any discussion of this aspect of international law is that much of the work that needs to be done to protect the environment cannot be done by national action. It's something which requires action in global spaces involving large numbers of countries, perhaps all of them. And even in those areas where national action does make a difference, if there's not some form of cooperation, some form of harmonisation, you run the risk of competing standards being imposed by different countries. Imagine a world in which a ship passing through the Mediterranean had to comply with completely different environmental standards every time it crossed a maritime boundary. Navigation would be impossible. But more seriously, that sort of approach encourages a race to the bottom at the time of recession and the use of environmental protection as an excuse for introducing disguised forms of protectionism. Now, I have to admit here that the way international law is made by agreement in the treaty-making process poses a really serious problem for any attempt to tackle climate change, because there is no way of compelling states to come on board for a new treaty regime. The political will to do that has got to be found somewhere else. There's no legally coercive power available. But the fact that states are able to stay outside something like the Rio Treaty regime shouldn't blind us to what has been achieved in this area, for example, through the adoption of legally binding standards in relation to maritime pollution and a whole raft of other pollution problems over the space of the last few decades. The answer here seems to be that international law is not going to produce the change on its own, but it is an indispensable tool to ensuring that you have that change. And then thirdly, there's the question of rights, particularly the protection of the rights of the weak. Now, this was not traditionally an area of interest for international law at all. The way a state treated its own citizens was considered to be a matter for that state and that state only. Ironically, an exception to that always existed in the area of the laws of war. But since 1945, there has been a dramatic change here, starting with the Universal Declaration of Human Rights, and then regional treaties like the European Convention, the International Covenant on Civil and Political Rights in 1966, and then a host of specialised treaties like the Convention Against Torture, the Convention on the Rights of the Child, the Convention on the Elimination of Racial Discrimination. You've had built up a body of international law which, if it is applied faithfully, radically transforms the relationship between the individual and the state. Now, how effective is that? I think it has a number of important achievements to its credit. First of all, it has produced a sea change in attitudes. The notion that a state can simply say, how I treat my own citizens is nobody else's business, has largely faded from international society in the last 20 or 30 years. Geoffrey Howe made that point very tellingly in his lecture about the role of the Foreign Secretary here in the LSE a couple of years ago. Secondly, there has been agreement on a basic core of human rights standards, which simply didn't exist 2 generations ago. The prohibition of torture, the prohibition of summary execution, the prohibition of the arbitrary deprivation of liberty are now well established. No state is going to say today that of course we are free to torture someone if we wish. They will either deny that they do it, or they will say that what they do doesn't amount to torture. It really has become the international crime that dare not speak its name. Though I'd have to admit that actual compliance with those basic core of standards is far from satisfactory, and many of the other human rights standards that we hold dear are standards which exist more in a regional context than in a global one. Lastly, there's been the growth in mechanisms for securing compliance with those human rights standards. Now, many of those operate only at the regional level, the European Convention system, for example, which has had such a dramatic effect in this country. But even the global institutions, which have historically been rather weaker than their regional counterparts, have made a considerable difference. Not least because the very fact that it is known that someone is complaining about your treatment and that your case is attracting publicity has often gone a long way towards ameliorating the conditions in which a prisoner was held. During the Iran-Iraq War, it became clear that any prisoner of war whose name found its way onto an International Committee of the Red Cross list of POWs had a far better chance of surviving the conflict than did those whose names were simply not recorded. So what I'd suggest to you in conclusion, ladies and gentlemen, is that the debate about whether international law can change the world has been conducted historically on a false premise. You take a dreamlike, or if you're one of the Bloglodites, a nightmarish vision of what the world might become. You then judge international law harshly because it hasn't achieved that dreamlike vision, the vision that Tennyson put into verse and the authors of the Hague Peace Conferences sought to put into treaty form. But that was never achievable without a radical political transformation for which the world has simply not had the appetite. It is surely better to look at what international law has achieved, for example, since the Second World War, and compare it with what might have been if there had been none of the laws and institutions created in that period. And the world would then have been a much bleaker place, a place in which the way a state treated its citizens was still its exclusive preserve, in which the carving up of the world's oceans and seabeds would have been an almost imperialist snatch-and-grab raid, in which there was no check on the power of states to impose tariffs, quotas, discriminatory barriers to trade, despite the history of how that failed in the 1930s. So my answer is yes, international law can change the world, and in a way which would have been far too modest for Tennyson, but which might perhaps have surprised Morgenthau. International law has already changed the world. Whether it will change it further, whether it will change it for the better, is critically dependent upon whether there is the political will to enable it to do so. Thank you.